the table to your right. We're going to review your file.
Jeremy Butcher, Mallory Copley, Nathan Cox, Tiffany Crabtree, Denise Faulkner, Brandon Helton, Sabrina Pettiford, Amy Jo Piles, Daniel Cox.
Okay, Jeremy Butcher is here, 19480. And 18259, yes. How are you, Mr. Butcher?
I'm good.
Okay, it's a good report. You're looking good. Nice uniform. And you made a payment on your fines, so. Everything's going okay?
Yeah.
Good. What's best for your work schedule?
Anytime.
October 13th. 9 o'clock.
Thank you.
You're welcome. Have to restart the scheduler, it's not working.
Was that earlier? I'm sorry.
Well, sometimes it's like it gets stuck, it's frozen, it won't change from one month to another. I have to log out and log back on. I'm gonna have to reboot the whole computer. All right, Mallory Copley,
Yes.
22-16-13. You have very little left on your fines. You got $60 left on your fines, but you have community service to do.
Yes, I'm paying off the rest of that today for my fines, and I also have the hours that I've done for community service so far on the log.
Your Honor, she did just turn in 30 hours of community service.
No.
No, 10 hours.
Yes, I have to do 30 hours.
She's got 30 to do, and she's turned in 10.
Yes.
Okay, and that's from what?
Boys County Community Work Program.
The CARES Community Kitchen.
I'll have to call and verify it.
All right. I'll set your next hearing for October 13 also, 9 o'clock. And you're going to see the clerk to pay the balance?
Yes.
Okay.
Do you need a copy of this?
Yes, if you can. Thank you.
Name and Cox.
Thank you, Your Honor.
You're welcome. 22-16-63, 21-30-62, 21-19-17. Actually, you paid that one off. Okay, you've got quite a bit of community service to do, and I don't see you've done any. Tell me about that.
I'll be doing some of that very, very soon in the near future.
Well, like when?
I'll
I need a date.
I'll definitely have some done before I get back in here for my
No,
next
I
one.
want a date when you can be here. This has been going on, you got a 21 case number and a 22 case number with community service, and you haven't done any of it yet. So we're gonna get a
Don't have it.
commitment on a date. You can pick any day, but Sunday or all day.
Can you give me a month or something?
No. I want something done in the next week.
Okay, so.
Pick a day. Saturday?
Are you
Coming Saturday.
court Saturday? Like, I mean, are you wanting me to have
No, I
something
want you
done
to be here to
by?
do community service this Saturday at 7:30.
I can probably do that, yes.
I'm sorry?
I can do that, yes.
Okay, put him down for this Saturday. That's the 9th. Be here at 7:30. And are you working now?
I'm currently working, but work has been very slow due to weather and other situations. I work outside,
Okay.
do logging.
Well, you gotta get some of this done. I mean, this has been dragging on for a while. So it's gotta get completed.
I don't currently have anything with me today to pay on fines either before you ask, but I do plan on, bringing a lump sum in very soon.
All right, I'll set your next hearing for September 29th for review. You have him down for Saturday for community service. You'll let me know if he doesn't show up.
Yes, Your Honor.
Okay, September 29th, 9 o'clock.
What time do I be here again? Sorry.
7:30 on Saturday, on the west side of the building. Okay, that's all.
Have a good evening.
Two. Okay, now it's working. Tiffany Crabtree, 22,698. Okay, you just have fines and court costs to pay. Can you pay on those today?
Yep,
How much are you paying?
50.
Okay. See the clerk, make your payment. I'll set your next hearing for October 16th. You pay it off, you don't have to come back. 9 o'clock, October 16th.
Okay, I'm just gonna pay it. Not today, but,
Before then,
Yeah.
that's fine. Pay it off, you don't have to be here.
okay. That all?
Yes.
Thank you.
Denise Faulkner, 21,1532. Hometown Recovery.
Yes, she's doing outpatient services with us. I have her treatment plan, her drug screens, progress report, and a court letter for you.
Great.
You can have those, I don't need them.
Okay, so much better report.
She's doing really good. She even came in over the weekend to make up a group that she had missed because she didn't have a ride. But now she knows she's allowed to drive, so she didn't think she was allowed to drive at first.
Okay.
And she's already made it up.
All right, very good.
Your Honor, if we can, we would like to ask the court to knock her days down. She works 2 jobs, 1 full-time, 1 part-time. We have her doing 5 groups, 5 case managements, 2 indies, and 2 drug screens, which is more than what we require of inpatient. So we would like to see if we could knock her down to 3 days a week, 3 groups.
That's fine. Whatever you're recommending,
Okay.
I'm okay with that.
Okay.
I don't make the treatment decisions usually. Now, sometimes I'll decide if it's inpatient or outpatient.
Right.
Yeah, that's
I just felt
fine.
like that was a lot for her.
Okay, I'll set you for October 16th also as your next hearing. Are you paying anything on your fines today?
I'll pay $10 today.
Okay, I see that. October 16th, 9 o'clock is your next hearing.
Thank you.
Okay, much better report, thank you. Brandon Helton has been called for, has not appeared, 23/18, 21/53. not completed, so there will be a warrant issued. Okay, Amy Piles,
Yes, sir.
17,280, 17,154, and 15,970. Two of these have been paid off, only the last one, 280.
I paid
And
one
you did
off
make a
today.
payment today.
Yeah.
Okay, October 13th is your next hearing.
All right, thank you.
Get it paid off, you don't have to come back.
Thank you.
Sabrina Pettiford, it's been called for, has not appeared. She still has things left to do. It's 22,104 and 02,214, so it'll be a warrant for failure to appear. Daniel Cox, 08425, is here. Community service done, you just have to pay on your fines. Do you have a payment today, sir?
Yes, sir.
How much are you paying?
60.
All right, Cedar Park. And I'll set your next hearing for October 10th. That's a Tuesday. Because Columbus Day is the 9th.
Your Honor, if I may, he has a preliminary on the 29th. I don't know if you want.
Oh, okay, thank you. We'll put it on the same day then.
29th?
September 29th will be your next review hearing, but you'll have to stay for both. Okay, that's all.
Thank you.
We're going to start arraignments now. That's the new cases. Anyone out in the hallway or in front needs to be in the courtroom now for arraignments. So you have a right to remain silent if you're a criminal defendant. You don't have to say anything. If you choose to make statements, what you say is all down on the record, so it can be used against you if you admit something about your case. You have a right to have an attorney, to have one appointed if you're facing jail time and you can't afford one. If you meet the financial guidelines for appointment, I have to ask you about your income before I appoint a lawyer for you. I have to determine your gross annual income. You have a right to have bail, to make the state prove any charge beyond a reasonable doubt. Those are the rights all defendants have. If you enter guilty or no contest plea, you're waiving those rights. You shouldn't do that unless you fully understand what's happening. If you want to talk to a lawyer, if you want to have a trial, you definitely need to enter a not guilty plea. Or if you don't know what to do, enter a not guilty plea. Call the first case. What's that? Oh, it didn't matter. That's fine.
State of Ohio versus Jaron R. Edgington, case number TRC 231190.
Answer, are you Jaron R. Edgington?
Yes, sir.
Mr. Edgington, it's alleged that on August the 27th at 2:12 a.m. in Fayette Township, you were operating a vehicle while you were under the influence of alcohol, and the state's alleging you took a breath test and tested 09 on the breath test. And it's alleged this will be your first offense. The per se level under Ohio law is 08. And what that means is if there's a test score above 08, if the state follows the rules for giving the test, there's a presumption that you are impaired if the test score is above 08. To get the presumption, the state has to show compliance with the rules for giving the test. The maximum penalty on this offense is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose. There is a minimum, so the least the court can impose if you're found guilty is 3 days in a treatment program $375 fine, and a 6-month license suspension. Do you understand that charge and the possible penalties?
Yeah,
You're also, well, that's the only charge you have. You just have one charge. Do you understand the rights you have as a defendant?
yeah, yes, sir.
Any questions before you enter a plea?
No,
What plea do you wish to enter?
guilty. Guilty
Means you're admitting it's true, you're waiving any right to have a trial and a lawyer. If you enter a guilty plea, you understand that, and you're also admitting the charge is true. You understand all that?
Yes, sir.
Okay, I'm going to accept your guilty plea. And I'm going to read the report into the record that the officer submitted. The report says on August 27th, I was traveling west on County Road 1. I ran the registration of the vehicle in front of me. It did not come back to the vehicle that was in front of me. I initiated a stop, approached the driver's side, and made contact with the driver, asking for his license, which he provided. And his name was Jaron Edgerton. Mr. Edgerton stated the vehicle was not his. He stated he had been in Huntington with some friends when he realized he did not have his keys. He stated he was on his way back to his friend's house to get his keys. While talking to him, I could smell a strong odor of alcohol coming from the vehicle, and his eyes were bloodshot. Asking how much he had consumed that night, he stated he'd had a few drinks earlier and not had anything to drink since about 7 p.m. At this point, I had him step out of the vehicle. I looked through the window and saw an empty Busch Light can laying on the floor. I asked him about it. He said he did not drink any beer that night. He said he had a few shots with his friends at around 7 p.m. Well, my vehicle, I could still smell an odor of alcohol coming from his person. His eyes were bloodshot. I asked him if I could check his eyes to make sure he was okay to drive. I had him perform the horizontal gaze and nystagmus test. Also walk and turn, and one-leg stand. It says there were 6 clues on the HGN test, 4 clues on walk and turn, and 3 clues on one-leg stand. Offered him a portable breath test, which showed a score of 0.92. He was placed under arrest, given Miranda rights. Vehicle was secured, transported to the STEM school where he was read and shown the BMV, and he agreed to give Toxilizer 8000, which he did at the post. It showed a test score of 0.91. Released to a friend at the post. He was very respectful and compliant with all my instructions during my interactions with him. Okay. Any statement or explanation you wish to make, Mr. Edgerton?
Exactly how it happened.
Okay. Are you working, a student? What do you do?
Right now I'm unemployed, but I'm going to get a job.
Okay. I'll impose a $450 fine, order you to pay court costs, 6-month license suspension that started the date of the incident, 20 days in jail suspended to 5 days of community service. You have to go to a 3-day treatment program, and I see, do you still live in Portsmouth?
Yeah.
The treatment program is in Portsmouth now. There's not one in Lawrence County any longer, so you can go to any one that's approved by the state, but that's the closest one that's in Portsmouth. And when you talk with the probation officer, he'll give you the contact information, how to get that. So that's the driver intervention program. You have to do that or go to jail, so you'd rather go to the 3-day program than go to jail, I'm sure.
Yeah.
So I'm going to allow you to have a permit to drive You do have proof of insurance. You'll have to maintain that. It's going to go up now if you got an alcohol-related offense. I'll let you have a permit to drive, to seek work, to come to community service, to go to the 3-day school. So for all those reasons, you can drive. Is there any other emergency things you would need to drive for?
I live with my grandma, and my grandma's like, it's really hard for her to get around and stuff, so she has me do like odd things for her, but nothing really.
Okay, I'll allow you to transport her for medical and necessities. Okay, his review hearing will be March the 4th of next year. So you've got, if you were here earlier, we had review hearings. That's for people who come in who haven't finished what they're ordered to do and show up. If you get everything finished before then, you don't have to show up for the review hearing. That's a hearing to make sure you do what you're ordered to do. If you haven't finished it, you gotta show up. If you don't show up and you haven't done everything, you get a warrant. So, you should not go to jail on this, but people do go to jail because they don't, if you blow it off and don't do it, then eventually you'll get picked up on the warrant and have to go to jail. I don't want you to go to jail. Just do what you're supposed to and you'll never see the inside of the jail.
Sir.
So, you're gonna meet with the probation officer. Everything I just told you is gonna be on a piece of paper called judgment entry. He's gonna give you a copy of that, and he'll be your contact person with the court. You can do your community service in Scioto County if you want. He'll explain to you how to do that. Make sure you talk to him about that. And also getting the driver's permit, he'll give you that also. So, he is here there.
No.
All right, Mr. Cooper, you're gonna see Mr. Cooper about that. So he'll talk with you. You want to meet him in the probation office or where? All right, when you leave the courtroom, make a 90-degree left, go to the west side of the building, that open counter there. That's where Mr. Cooper will meet you. Any questions of me?
No, sir.
Okay, talk with him, and then after you've done so, you're free to go.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Nathan Boyd, case numbers TRC 21331, TRC 202434, A, B, C, and D.
All right, this was set for review hearing on August 28th, so that was a week ago, it looks like. Well, a week and 1 day. Okay, you've been to Foundation since you were last year, looks like.
Yes, sir. I checked myself in up there. I just had to completely get back away from the alcohol. And
And you're going back to PATH today?
yeah, I was there last week. I got my shot, and I have a meeting or a appointment with Jeremy West today at 4.
Okay, very good. Okay, I think I approve of all that. Now, you did make a payment on your fines. You still have some community service to do?
Yes, sir. And the job that I was working out of town, I don't know if you remember, I took a couple weeks off. I just went ahead and quit that job. So as far as making a payment today, I probably won't be able to.
Okay.
I've been out of work for a few weeks, but I'm working on getting another job.
All right, and then when can you do some community service?
This week. I was here Saturday, but I can.
Is that correct? Okay. Okay, I'll set you for October 10th. That's your next hearing, 9 o'clock. That's a Tuesday. October 10th,
Thank you, sir.
9 a.m. Okay, we've got some more arraignments that will be coming when the paperwork's completed, and we've got some at the jail to do, but we're not ready to go there yet, so we're gonna work on some pre-trials here at the court. So if people that have pre-trials need to come in, we need the lawyers to come in.
State of Ohio versus Christie D. Booth, case number CRB 23315.
Steve Booth and Mr. Scott's case set for pre-trials.
Your Honor, we asked for a subpoena to be issued, and
On Emma Bush.
yes, and I believe it was served.
The docket shows 8:30 service at her residence, Your Honor. It's been a couple of days. She's been properly served, and she is not here that I'm aware of.
So this is a case, Your Honor, to refresh the court's memory, family members were here,
Right.
and we talked about the fact that maybe they should all go to counseling, and they agreed, but it never happened. And the victim, despite our efforts to contact her and to get her here, has not appeared. So we're just going to have no choice but to nolly the charge.
All right, it'll be nollie.
It's for purpose of the record. Happy with the nollie, it's great, it's the outcome we want. My client did make significant efforts to get the alleged victim and the father into treatment. She's been going to therapy. I haven't signed affidavit that she's facilitated, she organized. Treatment facility even reached out to the alleged victim to get them there, and they never followed through with it. So there was effort on Ms. Booth's behalf to get that going. Now, on the issue of court costs, she's already underwent significant expenses doing this treatment, coming here several times. It's pretty standard for a defendant to be responsible for court costs. I would say that's incredibly inequitable in this specific case.
I'll waive them here. Be nollie without cause.
Thank you, Your Honor.
You're welcome.
Go in front, talk to you. Thanks, Bill.
State of Ohio versus Sheena Darby, case number CRB 1449. CRB 13963, CRB 12463, CRB 101029. Mr. Stiers, please.
All right, we need Mr. I don't know if you were aware.
I wasn't.
Okay. It's older cases. She came in on an old warrant. I set it for a pre-trial review, and I believe you were going to go to some treatment.
Yeah, I'm actually doing outpatient at RRG.
Okay.
So I've already made contact with them. I've had my first appointment. My second one is today at 3:30.
All right. Do you want to talk and come back, or how do you want to proceed?
What are we looking for in this, at this point?
For her to get into recovery and stay in recovery, and
So it sounds like she's gotten started on that. I don't know, does RRG have anybody here today?
not that I've seen.
Do they generally send somebody? I'm not.
Well, they have been, but of late, they haven't been.
At this point then, I think probably just set this out a couple weeks and try to get in here with a report. Or, a time frame that the court deems appropriate. I figure enough time for something to happen, but not too long to lose track of it.
Where are you living now, Ms. Darby? Are you back in South Point, or?
No, I'm still in Huntington, 2320, with my kids.
But you're still local? You're still local in Huntington?
Yeah,
Because I thought you, at one point, were you further away, maybe Parkersburg or something?
yeah,
Okay.
I did.
So I'm unavailable the 11th and the 15th, but throughout the rest of September, I'm here.
22nd?
22nd would be fine, Your Honor.
All right, next hearing will be September 22nd. And I'll let Mr. Webb know you were here today.
Can you wait for me out there? I'll keep a couple minutes.
Thank you.
You're welcome.
State of Ohio versus Buddy L. Hardy, case number CRB 23287, CRB 22600.
Sorry, there was.
PRC 23532, ABC and D, CRC 1870, CRA 1864.
I'm gonna ask them to recall this, so I can do it.
Your Honor, I'm going to ask to have this one recalled so I can speak to Mr. Hardy.
All right, case will be recalled later in the docket.
Just step out. All right. Thank you. I'll be out there in a few minutes.
State of Ohio versus David Pepper, case number CRA 23405, CRB 23406. David Pepper.
Your Honor, you may recall that when Mr. Pepper was last scheduled to be here, I was informed by his family that he was in Western Regional Jail. We rescheduled it today, so he would be out in time for that. As of this morning, he's still in Western Regional Jail. I think the state has a motion.
Your Honor, we're going to nolly the charges. We'll reserve the right to refile them or even take them to the grand jury.
Well, say one of them is a felony.
Yes.
Pretty serious felony.
Yes.
Okay, for the clerk likes to, or so we're going to enter it as a knowledge to the grand jury? Or?
Well, yes.
Okay, and that includes the misdemeanor also. So everything is knowledge to the grand jury. Whether you present it or not is up to you.
That's his job.
State of Ohio versus Gregory Wilson, case number CRB 23515.
It's Mr. Steyer's case for pretrial.
Your Honor, I've been speaking with the alleged victim, Ashley Webb, and our proposal on behalf of the state of Ohio is that if Mr. Wilson would agree to go to counseling for domestic violence and be successful and complete that counseling, then we would be agreeable to dismissing the charge at a later date with the payment of court costs.
Okay, Mr. Wilson is willing to agree to that, so I don't know. Have you started any kind of counseling? Okay.
How's he paid for it?
Do you have a medical card?
No.
Where do you live? Are you employed? Probably qualifies for a medical card, even though he doesn't apparently have one yet. Does anybody that's here be able to help him out?
I can do it. I can go to 501.
Well, yeah, but I mean, you're gonna get a provider as well, so. So you could help.
Yeah.
So Bethesda, sounds like they'd be willing. You're Bethesda, correct?
Yeah.
Okay, I can't always keep it straight, I apologize.
That's okay.
Bethesda's willing to speak to him, so I don't know what kind of a time frame the state's looking at on this. Do you wanna?
There's no protection order, there's no protection order requested, right?
That's correct.
Right.
About a month or so.
I think that would be appropriate, Your Honor.
And we would waive time to accomplish that, Your Honor. Month is, we've got October 2nd, it looks like, and 6th, and I'm here on the 6th already.
Okay, we'll do October 6th.
Okay.
Nine o'clock, Your Honor?
10 o'clock, but be here about 9:30.
he needs to speak with Taylor before he leaves. Come back in a month and we'll get a progress report. Hopefully it's a good one, and then if things go well, you can get this case dismissed.
All right, thank you, Your Honor.
What's the next date, Your Honor?
October 6th, 10 o'clock.
Thank you.
You're welcome.
Thanks, sir.
Make sure it goes to the council.
State of Ohio versus Adeline Timbers, case number TRC 23-1043, A and B.
This is Attorney Smith's case set for pretrial.
Yes, Your Honor, this is one that, after talking with Mr. Hill, I think we're going to file a motion to suppress, so we'll need to get a pretrial date.
Okay, so we're going to pretrial the motion to suppress.
Yes, Your Honor.
When can you have that filed?
Well, we can file it within the week. I'd say 10 days maybe.
We can just go ahead and set it.
October 2nd for pretrial.
That's fine, Your Honor.
Is that good?
You're good? You don't have?
No, we're back.
Okay.
All right, pretrial on motion to suppress is 10 o'clock on October 2nd.
And the defendant will waive time. Your Honor. Okay.
Thank you.
Thank you.
You're welcome.
Schmidt has another case, but there's a companion case with Roger.
I think Mr. Starr said he'd cover that one since my client is the victim for Roger's client.
Okay.
So
Mr. Stiers going to cover?
he's going to cover Mr. Van Bibber, and I have Cindy Van Bibber.
State of Ohio versus Cindy K. Van Bibber, case number CRB 23508. And State of Ohio versus William Van Bibber, case number CRB 23504.
I'm sorry, Your Honor, I stepped out to speak to Mr. Hardy.
This is Mr. Van Bibber. Roger.
Mr. Hardy will be here, but he's not standing for him, so let's just stay around. I don't know things are. Can't drop the motion, she said she wants to drop the motion. So their client not interested in pursuing the charge.
You don't want to pursue the charge.
So, Your Honor, this isn't my case, I'm not fully versed on it, but I was back there this morning when it was discussed, and it sounds to me as if the alleged victim is not wishing to pursue charges. I don't know if that's been discussed with the state, however, because she's represented by counsel on another matter.
Mr. Hill.
Your Honor, this is not a cross-filing. Cindy Van Bibber, when this incident occurred, was found to be in possession of drug paraphernalia.
Okay.
She pled guilty on August the 21st and agreed to go to ARC. So we'd like to have an update on that to see if she's actually going to ARC.
She is. She's in services with us. She's doing very well. On the most recent drug screen, she was only positive for THC, but she has been in services with us for outpatient.
So that was our goal on that one, Your Honor. And then on the other one, we would want to have a period of time to show that there aren't going to be any further problems before we would agree to dismiss the charge. Now, this is just speculation, but and I believe that they're husband and wife, you all married. She's got an indication that she uses drugs, and I don't know whether Mr. Van Bibber has issues that he should address through this too. And if he doesn't, then we don't have any other way of dealing with that, but we would suggest a 90-day continuance and a dismissal with the payment of costs if there's no further problems.
Mr. Van Bibber is agreeable to that, and I would waive time constraints on his behalf for Mr. Smith to accomplish that, and you can just pick a date that's appropriate at the right time frame.
December 15th.
I don't know if that's going to be good for Mr. Smith or not. I'll inform him that date, and if it's an issue, he can contact everybody and ask for continuance.
All right, be set in there for the time waiver on Miss Van Bibber. We'll come back in a month. Looks like things are going the right way, but we'll keep monitoring what she's doing on her treatment.
That's fine. October 2nd, we just set that date.
Second?
That's fine.
October 2nd will be the next hearing. I'll make it for a sentence. It should be on the docket as a sentence hearing. December 15th.
State of Ohio versus Jesse G. Conley. Case number CRA 23410, TRC 239090, CRV 23411.
Hey, Your Honor, Mr. Collins, are there two attorneys on this? Oh, ladies and gentlemen, the other attorney's not here, I misunderstood. I'm sorry. Mr. Conley's contacted me this morning. He's stating that he tested positive for COVID last night. I've advised him that I would seek a continuance, but in any event, he's going to need to bring medical documentation to the next hearing, and for that reason, I'm seeking a continuance.
We're not opposed, Your Honor.
You want to come back?
I'm not here the 5th or the 11th, so I would assume the week after that, but again, we're going to waive time constraints, so a date convenient to the court.
'18th or 22nd? 18th is one of those days. Mr. Field's not going to be here. The 18th,
I won't be here the 18th, Your Honor.
22nd.
22nd is fine with me, Your Honor.
September 22nd will be the next hearing at the request of the defendant, preliminary hearing and pretrial.
Thank you.
You're welcome. Mr. Kermes, do you realize Mr. Branham is in the back?
I'm aware, Your Honor. I've already spoken to him. We're about to put him in contact.
Okay, if we get his call, we can go ahead and do that.
I need what's his first name?
Dustin.
I need that file.
It wasn't on the docket today.
He was, that's correct, Your Honor. He wasn't on the docket. And I think they were working on putting him on the docket before I walked out here.
Okay.
You know how long he's been in jail?
Since 8 minutes ago. 10 minutes ago.
Branham. Yeah, he had Branham, Mr. James is out in the clerk's office.
Your Honor, the clerks are still working on the file.
I have it. I have it right here.
Oh, okay. Sorry about that.
So we need to bring, he's in the holding cell. So probably Mr. Cooper. Yeah.
And Your Honor, I've informed Mr. Cooper, but just so the court's aware, Mr. Branham's indicating that he has COVID.
Okay.
So just so the court's aware.
All right, Mr. Dustin Branham is present in court with his counsel, Mr. Cummings. There was a failure to appear previously, I believe it was it August 14th. And Mr. Sowards was on the bond. Actually, it was before then. There was a bond forfeiture on August 14th. The failure to appear was June the 16th. It's been that long ago. Wow. Doesn't seem like it's been that long ago, but the summer has flown by. June 16th, and then there was the first bond forfeiture was July 10th. Gave an extension to July 31st and August 14th, and then now Mr. Branham appeared today in court and was placed in custody. So, Mr. Sowards, how do you want to proceed on the bond?
Your Honor, I would like to be released from the bond. They've been uncooperative with me the entire time they've been out on bond. He's came, I think, twice and then left, slipped out and left before he was seen by you. He did come today, and I happened to be here, saw him pull in, went out front and was going to go and just put him in the holding cell to make sure he didn't slip out and leave again before he saw you. And he resisted. It took Wes and I both to get him cuffed and brought inside. So I would like to be released from the bond.
Mr. Cummings, do you have any response on that?
Your Honor, I wasn't on the case at the time that the initial failure to appear occurred. Upon coming onto the case, I filed a motion to dismiss. Upon coming onto the case, it was set at the same time, I believe, as the bond forfeiture. Last week, Mr. Branham appeared for that hearing. However, when he walked in, he was told that I wasn't here and that I wasn't on the docket, and assumed that his case wasn't, occurring at that time and left. I spoke to him prior to entering to the court last hearing, and he indicated he would appear here today. He's done so. I think he has the desire to get this resolved.
Okay, I'm going to allow the bond to be, I think Mr. Sowards has gone above and beyond trying to get him here, so I'm going to allow the bond to be released. How do you want to proceed on this?
Your Honor, procedurally, I don't know where we are procedurally. I filed the motion. I know the court had indicated at the last hearing its intent to deny the motion, but I don't know that that was because of whether or not that was Mr. Branham was here or whether that was on the merits. We didn't argue the motion. It was just where Mr. Branham wasn't here. I don't think there was a whole lot we could do.
Well, here's what the court would like to see. Actually, the history of this, he was ordered back in 2012 on a theft offense to get counseling for drug issues and pay restitution. That didn't happen back then. He failed to appear. Then he came in recently, and I think he had got picked up on a warrant. That's when the initial bond was posted, and he had brought with him a letter from his purported employer, Air Supreme, I believe was the name of it, with a very nice letter saying he was the manager at the facility and so forth. And I think he verbally told me that he had been in recovery for quite a while. So I asked him to do, since we didn't have he didn't comply with getting treatment. I had no indications that he'd ever done the treatment he was ordered to do, that he'd do a screen. And my plan was, and I really expected him to test negative because he's been working since 2020 with this facility, and they promoted him to manager in 2022, that he would test negative, and then that I would conclude the case based upon that. But he did not test negative, and he tested, 4 things, one of which, well, the 2 major things that we have going on in our community, one of which is killing a lot of people, fentanyl. So, and then, as I recall, when he saw what the screen results were going to be, he didn't stick around. He just took off, did not come back in and appear before me after he knew what the screen results were, and he's been, has not appeared in court again until today. So I feel, with what I know about fentanyl and the dangers of it and how many people are dying from it, that I could not just say, it's okay, go your way, continue to use fentanyl. It's 107,000 people in the United States died last year and of overdoses, and it's estimated that 80% of those overdoses were from fentanyl or a combination. So that's the history. I'd like to see him. I don't want him to lose his job. I want him to continue. I want him to do well. But I don't want to see him out there in the community using fentanyl either. And take, it's like playing Russian roulette. So that's my position. So,
Your Honor, perhaps another screen today may be worth checking.
Let's do that. If he's willing to do it, let's do another screen and see where we are now. So go do a screen and we'll come back after we get the results. So that case will be recalled later in the docket.
Thank you, Your Honor.
You're welcome. Buddy, all right.
State of Ohio recalls Buddy Hardy, case number CRB 23287, CRB 22600, PRC 23532, ABC and D, PRC 1870, CRA 1864.
This is Mr. Steyer's case.
Your Honor, can I just vote to speak to Mr. Hill?
Yes.
This is on the OBI. Comes up, he's not in the car, he's walking down the highway smoking THC. So I never really at the time. So
It's a second attempt. Is he willing to go to treatment, plead, and work on sentencing?
He's going to go to an assessment. I don't know if he's going to give him treatment if it's marijuana. Treatment for marijuana. But I don't think you have an OBI here.
Well,
Really, do you want to fight this one?
yeah.
Okay, well, let me talk to him. I'm not filing. He's not letting him move on. He said that if you'd be willing to go to treatment, you could plead and then do something later. I can't talk to him in the jail time about doing that. So my thought is to do a motion Because like I said, I got witnesses and stuff.
Well, that's not the one I'm worried about. That's not the one I'm worried about. That's not where the jail time issue is.
Your Honor, this is an OVI, well, there's two separate matters, but the one that is kind of the more serious of the two in terms of potential sentencing is the OVI. It is a situation where we don't have any observed driving, and we have an observation of the officer that we have him allegedly using THC after the accident. So I think this is one that there may be some issues on. I don't know if this is something, if that's really something that is something to be dealt with through a motion to suppress, because really there's not. I don't know what I'm looking to suppress. I mean, I guess maybe a probable cause issues are not an issue of driving. So maybe a motion may be necessary, or that may be one we would just want to set for a trial. I guess a motion is probably the route to go on this.
There is no test.
There's no test, and again, the officer did not observe him driving, found him on the side of the road. And this is the officer's version, found him on the side of the road vaping. And the officer alleges that what he was doing on the side of the road was THC. So even if the officer is correct that it was THC, that doesn't do anything to indicate intoxication while driving.
It says driver of Unit 1 admitted to using drugs as he was operating the vehicle prior to the crash.
Excuse me. Also the issue of that there's a head injury involved in the crash that he was treated for down the road. I said, I don't know if that's something that the court would want to deal with through a motion to suppress.
How's the state want to proceed?
Well, certainly, if he files a motion to suppress, we'll defend that, and if we have a trial, we'll defend that.
I think a motion is probably worth filing then, Your Honor. I'll go ahead and put a motion together.
So you want to do a pretrial on the motion? When can you have the motion filed?
I can probably have the motion filed by Friday of next week. I don't have a day where I'm in the office this week because of the holiday. So I can have it filed next week. I'm sorry.
How about the 20, we could do the 25th or the 29th for a pretrial.
Either of those days is fine, Your Honor.
Let's do the 25th. September 25th for pretrial on the motion.
We also have, Your Honor, a criminal damaging charge where the allegation is that Mr. Hardy fired a gun at a car. They say it was a BB gun maybe, and hit the window of the car and shattered glass, and there was a young person in the back seat of the car. So that's serious on its own. So we want to, I don't think that it happened on different dates, so I don't know if they would be appropriate to try together. They both, this needs to be tried unless he's willing to enter a guilty plea to that too.
I haven't received an offer on that separate from the OVI, so if the state wishes to extend an offer, I'd certainly communicate to my client and discuss it with him, but at this point, we've only gotten a global offer.
Our offer was a plea to both of them, 60 days in jail with 40 suspended. He would need to do 20 days in jail, and that is because on the OVI, this is a second in 10 years plus a refusal and an additional in 20, which makes the minimum 20 days in jail. So he could do both of them together, and we would ask that the sentences run concurrently. The restitution on the windows is $50. That's the deductible.
Okay, is there an offer of, if it's...
So again, we have a global offer, so I would just say we can deal with that down the road once we figured out what the OVI situation is, and we'll continue to wait time constraints to accomplish that.
All right, September 25th, pretrial motions.
Okay, do you care if I keep this?
No,
All right,
I got copies of
sure.
everything.
All right, thank you. Thank you, Your Honor.
All right, we're kind of stuck. We've got 2 lawyers that are not here yet, so we can't go forward with their cases. So we're going to take a recess. Court will be in recess till the lawyers get here.
I don't think Amy's gonna show. I don't think Amy's gonna show.
He's not here yet.
Who's that?
Kenneth Roberts.
Kenneth Roberts.
That's the sentencing that's set for today. That's Diane. I don't know.
I don't think he's gonna show.
We have a file.
I don't know. What time do you be at work?
I'm supposed to be working at 9:30.
I mean, you could always call me later. I don't know. I don't know what they'll do.
How's it going?
You want to go back in the shack and talk to your
Do you need me to stay?
Yeah.
Sean, do you think Kenny Roberts has shown up?
Is he not here yet?
Can you just wait a few minutes, let them have time to talk about it?
Yeah.
Okay.
Yeah.
One of those days, I didn't take a clue on the times. So he's not here yet?
He's not.
Well, he should have had the full assessment with Bethesda.
I need to make copies of these. Detention orders. Make copies.
Oh, you're probably one of them, yeah.
Okay, let's go back here. Chat.
Grab the files.
You bet. Do you have one of my trials today?
I do not.
Do you not have that?
That's right, it would be a jury trial.
Good morning, Philip.
I got to bring your wife out of retirement. Huh? I got to bring your wife out of retirement. Need your help, man?
Any change?
They get this for evacuation. Sounds like everything. So I guess I need to get in touch with my, your cardiologist. Absolutely. Curry, he kept having symptoms of it, kept kind of ignoring it. And he's been on TV doing commercials now saying, don't ignore this. And I'm going to say, especially what I've been thinking. Right. You creep after your body. You'd be going through the airport, he said, you couldn't walk out of the yard, so they had to sit down and rest. And shortness of breath, shortness of breath. No, I've got that. And I've been here in the COVID. Yeah, yeah. But it would make you have to make me that because that's what he said. I mean, I think Kareem would do it to a bar. He'd be out down the basketball court like crazy. And I think I had her. She once canceled because the anesthesia was just a little bit. That's what it is. They did picture of the ground. That's what my wife says is recall. You see, yeah, and freezing, just freezing. That's what she says is going on with him, same thing. Yeah. They asked me to look up some fun supplements that I got. This, yeah. Well, in the desert. Stratton's right up town. Yeah. We're gonna get going soon. Okay, yeah, that's it. Yeah, we're all good. Okay.
Hutchison.
Last time, I think.
Mr. Stanley. We have Mr. Stanley here today.
They may be out in the lobby.
I'm headed that way. Ron Bryan is going to cover for me, and I'm headed to the dock.
Yeah, this is Ron, Municipal Court of Chesapeake. I need to get our guys in the chair and get on our screen here, we're ready to call Well, it's the same order that they sent out here to me. It's Allison Chapman, Corey Cordell, Daniel Hackbrook, Lars Hill, and going on. The same order they sent them to me. Okay? Thank you.
I mean, we at least know you were here. And you can call me later, because I don't have to. Because he's not here so far. You're probably right about that.
May I have your attention, please? Court's now back in session. State of Ohio versus Olivia L. Gilpin, case number TRC 231291, A and B.
All right, Olivia Gilpin, that's you, ma'am?
Yes, sir.
Were you here when I explained the rights of defendants?
Yes.
All right, this is case number TRC 231291 and CRB 23539. The traffic case alleges that on September the 3rd at 12:25 a.m. in Perry Township, you were operating a vehicle under the influence of alcohol, drugs, or a combination of those two things. It's alleged that you refused to take tests and that this is a first offense for you. So on a first offense, the maximum penalty you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. There is a minimum penalty the court can't go below if you're convicted. The minimum is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You understand that charge?
Yes, Your Honor.
You have another traffic charge, driving outside your lane. That's a minor misdemeanor. No jail time. Maximum penalty for that is $150 fine. Then you've got a criminal charge. Case number 23539 is resisting arrest. It alleges that on September 3rd, you recklessly or by force resisted or interfered with the lawful arrest of yourself. That's a second-degree misdemeanor. The maximum penalty is 90 days in jail, $750 fine. So do you understand that charge?
Yes, sir.
Do you have any questions before you enter a plea?
No,
What pleas do you wish to enter?
not guilty.
Do you wish to be considered for a court-appointed attorney?
Yes, sir.
Are you working?
No,
You don't have any income?
no, sir.
Okay. I'll appoint Mr. Stratton to represent you.
I've done better.
Yes.
I've entered a not guilty plea,
Yes, Your Honor.
and let's see. Did you post a bond, man?
Yes,
Let's have bond be continued.
I thought I saw a bond in the file, but I'm not seeing it now. With Mr. Sowers?
yes, sir.
Okay. All right, I'll continue that bond that you posted. Do you have a preference for a pretrial? We could do anything the 22nd or after September.
Oh, 22nd would be great, Your Honor.
Okay, September 22nd will be the pretrial at 10 o'clock.
So, just go
Not guilty plea is entered.
Okay, and I'll come out and talk to you, so don't leave just yet. All right, thank you.
You're welcome.
Yeah, but don't leave, I'll be right out.
State of Ohio versus Allison L. Chapman at the Lawrence County Jail. Case number PRV 23535. Corey Cordell is on deck.
All right, ma'am, you are Allison Chapman?
Yes. Recording has started.
Ms. Chapman, I'm Judge Capper at the Lawrence County Municipal Court. This is your, what's called an arraignment hearing, the purpose of which is to tell you what the charges are, set bond, take a plea. You have a right to remain silent. You don't have to say anything. If you choose to make statements, they can be used against you. If you admit something about your case, you have a right to have an attorney appointed, to have bail, and to make the state prove any charge beyond a reasonable doubt. Do you understand those things, ma'am?
Yes.
You're charged with a theft offense. This was faxed down to the jail this morning, so you should have a copy of the charge. It was faxed down about a half hour ago. It alleges that on September the 2nd, in Fayette Township, you tried to deprive Walmart of property without their consent. That's a theft charge, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge, ma'am?
Yes.
How do you wish to plead to the charge?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes.
Okay, I'll appoint Attorney Tyler Smith to represent you. He's in the courtroom now, entering a not guilty plea for you. I've got a Glenwood, West Virginia address for you, Ms. Chapman.
No, it's a different address.
Where do you live now?
It's 530 Vine Street West, Huntington, 25704.
What's the state's position on bond for Ms. Chapman?
State's not opposed to OR bond, Your Honor.
Okay, ma'am, I'm going to let you sign a signature bond. What that means is you're going to sign a piece of paper that says, I promise to come to court as I'm ordered to. And if you don't show up, then you have to pay the amount. It'll be $1,000 plus you get a warrant for your arrest. So if you come to court, you won't have to post any money. So $1,000 signature bond. Setting cases, Mr. Smith, for September 22nd or after. Any day after that. Or on that day, September 22nd or after.
I can do the 25th or the 2nd. If you want to keep it on Monday, it doesn't.
Let's do the 25th.
Okay.
September 25th, ma'am, is going to be your next hearing day. That's the last Monday in September. You have to be at the court in Chesapeake. So, do you know where the court is located?
Yes.
Okay, it's on County Road 1, Old US 52. You got to be here September 25th. If you don't show up, you'll get a warrant for your arrest issued. Mr. Smith is going to be your attorney. He wants do you have a cell number where he can reach you, or any cell? It could be landline, just so you can do a cell phone. Do you have a phone number where you can be reached?
Yes. It's 681-306-3224.
All right, thank you.
All right. Do you have any questions, ma'am?
No.
You'll get out of jail today, but you got to be back in court September 25th, the last Monday, 10 a.m. at the court in Chesapeake.
Thank you.
You're welcome.
State of Ohio versus Corey A. Quarles, case number TRC 23906, A, B, and C, and Daniel Hackworth is on deck.
All right, Corey Cordell was Roger's case. He's already been sentenced, but he was kind of balking at going to inpatient treatment on Friday.
Is RRS a possibility?
I'll let them talk with you. You want to talk with him, or?
Yes.
I think I was informed he did not want to go to a faith-based facility.
Fine with me.
All right, so we'll let Mr. Gwynn, we'll call down, talk to you, and we'll recall after that tap. They're going to call and talk to you, and then we'll make a decision as to whether they'll accept you or not. So we'll do that later in the document.
All right, thank you.
State of Ohio versus Daniel Hackworth, case number CRB 23538, Dolores Hill is on deck.
All right, sir, are you Daniel Hackworth?
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake, where your case is filed. You are appearing in the court by teleconference on a monitor in the courtroom. It's all being recorded, so if you say something that is incriminating, the state can use it against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove the charge beyond a reasonable doubt. Do you understand these things?
Yes, sir.
You're charged with a theft offense. The state's alleging that on September the 2nd, you purposely tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead to this charge?
Guilty, I guess.
Well, you gotta be sure. Are you sure you want to enter a guilty plea? If you enter a guilty plea, you're admitting it's true, and you're waiving the right to have a trial and to make the state prove the charge against you, and to have an attorney. You understand all that?
I'm not guilty.
You want a lawyer appointed to represent you? Yes? You want-
Yes.
Do you have a job?
Yes, actually,
What do you do?
I work at Municipal, detective.
Oh, in the food service?
Yes,
Are you paid by the hour?
yes,
How much per hour?
and
Okay, you're qualified for a court-appointed lawyer. I'll appoint Mr. Stratton to represent you.
Your Honor, is he in on the theft case? This
Yes,
Walmart
he's on
theft?
a Walmart theft,
Is that what's holding him?
as far as I know. He has I have a Hillview Drive, Huntington address. Is that the correct address, sir?
yes,
State's positional bond.
Your Honor, it's alleged that Allison Chapman is also
Previously
with him.
arraigned, the co-defendant,
Yes, and I didn't know if Mr. Stratton had been appointed to represent her.
I think.
Oh, do you mean Alice
Allison Chapman?
Chapman? No.
I think that was Mr. Smith.
Yeah,
That was me, Your Honor.
Yeah.
So we don't oppose an OR bond.
Okay, I'm going to let you sign a signature bond, Mr. Hackworth. You are promising to come to court as ordered, so we'll set, I think we set it for the 25th. I'm sorry.
that works.
1,000 that work. Mr. Smith, what is it, September 25th? We set the-
25th, Your Honor.
All right, we'll set this the same date, September 25th, for pretrial, 10 o'clock. Mr. Stratton's appointed as counsel.
Yes.
Okay, you've got to be at the court at Chesapeake on September 25th at 10 a.m., or you'll get a warrant if you don't show up, Mr. Hackworth.
All right, I'll be there.
Okay, you'll get out on a signature bond today.
Your Honor,
And we need a phone number for you for your lawyer, how to get a hold of you.
614-732-9517.
9517?
Yes, sir.
thank you, Your Honor.
Okay. All right, September 25th is your next hearing.
All right.
State of Ohio versus Dolores Hill, case number CRV 23536, and Aaron McCoy is on deck.
This can't be right. What down here?
Ma'am, are you Dolores Hill? Yes, sir. I'm Judge Capper of the Lawrence County Municipal Court. This is an arraignment hearing for you. It's the purpose of the hearing is to make sure you understand the charge, take a plea, set bond. You have a right to remain silent. You don't have to say anything. If you choose to make statements, it's all going down on the record. If you admit something that's incriminating, the state of Ohio can use it against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove the charge beyond a reasonable doubt. You understand those things?
Yes, sir.
You're charged with domestic violence. The state's alleging that on September the 4th in Chesapeake, you knowingly caused or tried to cause physical harm to Lou Ann Sniff. That Lou Ann is either a member of your family or a member of your household. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, I plead not guilty for domestic violence.
Do you wish a lawyer appointed to represent you?
In West Virginia, I'm fighting domestic violence.
as we speak.
Do you want a lawyer appointed here to represent you?
Yes, so I can go to West Virginia and still fight domestic violence.
Okay, do you have a job?
I get Social Security like my mother.
Okay. I'll appoint a lawyer for you, so I'll appoint Mr. Smith. So where's your case in West Virginia, Cabell County?
Yes, sir. I have a PTS case and a domestic violence case and a rape case, all one bundle.
Okay. All right, I'm going to appoint Mr. Smith. What's the state's position on bond and protection order?
Well, we're going to need a protection order. And then it sounds to me like the situation she has in West Virginia could be very serious, so we don't oppose an OR bond as long as she stays away from her mother.
I will.
Do you live someplace other than with your mother?
At the moment, yes, we're looking for a place active right now at the DSSR in West Virginia. We are actively looking for a place. We do have a place to go in West Virginia. The only reason why we travel to Ohio is to get my luggage. My mom is because my dad is deceased in his hometown of West Chesapeake, Ohio. That's kind of went kind of, high in society. So if I stay with my mother, that's fine. I'm 31 years old. I'm more capable of raising my own daughter with domestic violence, order, protection. That's fine. I no longer need my mother in my life. But,
All right, ma'am, he just wants to know if you have a place to go to away from your mother.
yes, in West Virginia, yes.
Okay, do you have an address yet?
Yes, it's in Ripley, West Virginia.
Okay, what's the address?
I only know one is Duck, West Virginia. It's Nathan Beard's grandma's house. It's the only address I know, but his sister's in Ripley.
Okay, do you have a phone number then?
Yes, it's 304-563-1974.
Okay. And are you going to go to West Virginia if you're released today?
Yes, he is. He has a driver's license for West Virginia. His license is valid. I picked him up in Cross Lanes.
Okay, well, that's not what I'm asking you. Are you going to go to West Virginia when you get released from county jail?
Yes, sir.
And you'll be staying in West Virginia away from your mother?
Yes. Yes, sir.
Okay. Well, I have your number now, so I'll get in touch with you to try to get an address at a later point, so we'll have an address where you're staying. Okay?
Yes.
All right.
Yes, sir.
State's position on bond.
Well, it sounds like the situation she has in West Virginia could be very serious. We're not opposed to an OR bond as long as she's not going to be around her mother. And I wanted to clarify, I thought she said, in addition to Ripley, I thought she said she would duck West Virginia. Maybe I misunderstood.
Yeah, the grandma is located in Duck.
Grandmother.
Okay, so you're not going to be with your grandmother in Duck?
No, Nathan's grandmother is in
Oh,
Duck.
Nathan's, okay.
Okay, I'm ordering you to stay away from Miss Sniff, which I understand is your mother. When would you like to come back for the next hearing?
25th, Your Honor. That's fine.
All right, your next hearing is going to be September 25th, and it'll be at the court in Chesapeake. This is on County Road 1, fairly close.
Yeah.
Do you know where it is, the court?
Yeah, it's beside the flea market.
Yes, that's our claim to fame. Just should change his name to the Flea Market Court. More people know that than anything. All right, September 25th at 10 o'clock is your next hearing. Mr. Smith has your phone number. You guys stay away from your mom while this case is pending. Okay, so you'll get out here in a little bit.
State of Ohio versus Aaron McCoy, case number CRB 23534, and Jason McCoy.
Ma'am, are you Aaron McCoy?
Yes.
Ms. McCoy, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake, Ohio. This is your arraignment hearing. I'm going to go over the charges with you to make sure you understand them and take a plea from you. You have a right to remain silent. You don't have to say anything. If you choose to make statements, what you say is being recorded. It can be used against you if you incriminate yourself. You have a right to have an attorney and to have one appointed if you can't afford one. You have a right to bail, and you have a right to make the state prove this charge beyond a reasonable doubt. You understand those things? The charge is domestic violence. It alleges that on September 5th in Proctorville, you knowingly caused or tried to cause physical harm to Jason McCoy, and that he is a member of your family or household. So that's why it's a domestic violence charge. Maximum penalty, 6 months in jail, $1,000 fine. You understand the charge? You had to make it, well, let me ask you this. What plea do you wish to enter? Well, you should be sure this is a pretty serious charge, and if you plead to it, it goes on your, this is one of those that stays on your record and it causes any future charges to be enhanced. So you need to be sure if you're wanting to enter a guilty plea to this charge. Are you sure you want to enter a guilty plea?
I'm not sure.
Well, if you're not sure, you should enter a not guilty plea.
Okay, not guilty.
Do you have money to hire a lawyer?
No,
Do you have a job?
no,
Do you have no income coming in at all?
no, stay home with the kids.
Okay, well, we'll appoint a lawyer for you. Mr. Stratton?
Yes, sir.
I'll appoint you. And let's see, I've got a State Route 7 address for you in Proctorville, is that correct?
Yes,
Okay, do you have a phone where you can be reached for your lawyer?
yes,
What is that?
304-360-7545.
And her name's Erin with an E, E-R-I-N McCoy. And do you want to, let's see, well, is there a protection order sought here?
Your Honor, there's a cross-filing, and Jason McCoy is her, I guess, spouse.
Well, I guess we need to ask her. Do you want Jason ordered to stay away from you while these cases are pending?
Yes,
Okay.
Yeah, so,
Where are your children now?
they're at home with my mom.
Your mom lives with you,
No, mom lives in Huntington, West Virginia.
but she came over when this happened?
Yes, she called the police for me.
Okay.
It was on the phone while it was going on.
Your Honor, we asked for exclusive use of the residence, so the protection order.
Mr. Hill?
Well, Your Honor, in reading the affidavit, which obviously has not been proven, but it's still something that we need to be guided by. Law enforcement called, or somebody called the grandmother to come to take care of the children. And the children are 15 and 11, so they're not infants. And they had some things to say about what was going on. And then there's a 7-year-old too that's apparently autistic. I'm looking to see whether Children's Services was alerted. But it's a pretty serious situation, and honestly, I think we'd like to have Children's Services pay a visit before we would agree that either Aaron McCoy or Jason McCoy should be back in the home. Maybe the children should go elsewhere. And of course, there's going to be a protection order, so that makes things even more difficult.
Your Honor, I have not reviewed the narrative, so if we're going to issue a protection order, is it against each other?
Yes.
Okay. So it's not against the kids?
No, it's not. But they are quoted in here, or summarized what they told law enforcement.
So, Your Honor, I guess what it's...
I'm reading the affidavit.
Okay.
Yeah.
Okay, it sounds like definitely from reading the affidavit, Children's Services needs to be alerted as to what's going on.
I've just sent a message to the supervisor there at Children's Services.
What do you want to do?
In the meantime, there's no charges involving children, but she says she wants a protection order. He hasn't been arraigned yet. So I guess we need to make it mutual probably. We'll see what he says. But. Okay, I'm going to order that you stay away from Jason. Since it's your mother that's staying with the children, I'll let you go back to the residence. Is this a rental place, or do you own it, or what?
We own the house.
Okay. All right, I'll let you stay at the residence with the children and your mother, assuming that we'll see what Children's Services does when we get there, but we put you in, I think it makes sense to allow you to stay there. We probably should come back pretty quick on this.
Yeah, I was thinking that.
So, either this Friday or next Monday.
Next Monday is probably going to be, this Friday probably better, Your Honor. I know it's a little packed, but...
The 8th?
Yeah.
All right.
Which has already been.
I'm going to set your next hearing in court for September the 8th, ma'am, at 10 o'clock at the court in Chesapeake. Do you know where the municipal court is in Chesapeake?
Yes.
Across from the flea market. You have to come here this coming Friday morning. I'm going to let you out on a signature bond, so you're promising to come to court, and you'll pay a $1,000 penalty if you don't show up, plus you get a warrant for your arrest if you don't show up. And I'm ordering you stay away from Jason, so I want the two of you to stay away from each other, at least till Friday. And then We're going to need a phone number for your lawyer. Do you have a phone where you can be reached?
Yeah, she gave it earlier. Your Honor.
Oh, she already gave it?
Yeah.
All right. All right, not guilty plea is entered. Next hearing is Friday at 10 a.m. Any questions? You're going to get out of jail here shortly.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jason McCoy, case number CRB 23537, and Kristen Chambers is on deck.
Hermines, did you see that?
I've got a copy here.
And sir, you're Jason McCoy?
Yes, Your Honor.
Mr. McCoy, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing, the purpose of which is to inform you of charges filed against you, take a plea, set bond, assign counsel if that's appropriate. You have a right to remain silent. You don't have to say anything, but if you choose to make statements, it's all going on the record, so anything you say can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
I understand, Your Honor.
You're charged with domestic violence. It's a first-degree misdemeanor. It alleges that on September the 5th in Proctorville, you knowingly caused or tried to cause physical harm to Aaron McCoy. That's a first-degree misdemeanor. It's a maximum penalty of 6 months in jail, $1,000 fine. Do you understand the charge?
They just threw me off. I heard you because you showed up.
I'm sorry, I didn't understand that. Can you repeat it?
Somebody popped up with a Burger King headset on the screen.
Oh, you didn't hear? Okay, let me go back over it again. You're charged with domestic...
No, I heard you.
Okay.
But somebody with a Burger King headset popped up on the screen.
Well,
I don't know, I have no one on it.
well, I don't know either, but they're not there now, right?
No, it's not. It was very weird. Yeah, I understand what I was being charged with, and you asked me for a plea or
Yeah, how do you wish to plead to the charge?
not guilty.
Do you want a lawyer appointed to represent you?
Well, from my understanding, I still have the lawyer on the paper.
Okay, so you think Mr. Lauder will represent you on this?
I haven't we're supposed to hear all that.
He doesn't take court appointments, so you would have to retain him to represent you.
I've already paid him.
Okay, well, that's fine. I'm not questioning that. I'm just telling you it would be between you and him. I'm going to put him down as your lawyer. I'm going to enter a not guilty plea.
Thank you.
And state's okay with an OR bond?
Well, I don't know what Mr. DeLauder is representing Mr. McCoy on already.
Do you have another matter where Mr. DeLauder is representing you?
Well, this is, there was a situation where there was a case in the past between me and the wife. CPS came up, our daughter's autistic, she's 7 years old, nonverbal. Can you hear me?
I can, yes, sir.
Okay, hey, just quiet here, so I just want to make sure. So, our daughter was injured at school, and when she was in school, CPS came to the house, they checked the bruises and stuff like that. And when they showed up at the house, my wife was looking for her first week. She applied for it, we were looking for a bag, got it. So we had to give her a let. CPS also came back another time for another person who was going to heaven. So Chris had represented us in there.
Okay. All right, well, I am going, well, let me ask you this. Erin says she wants you ordered to stay away from her. Do you want her ordered to stay away from you?
I want to offer a divorce, and she and I have been talking about that since our last talk with Crystal Otter, but we were supposed to go back and talk to her about legal separation. I have a job offer that I took, supposed to be in Charlotte, North Carolina today by 11:30, and I was flying out at 8:30 this morning. This happened last night.
Yeah, well, I don't think you're gonna make it.
I understand. The whole reason her mom called the cops instead of me is because she was drunk. And if she was just there and slept it off, none of that would have happened. And I apologize for, anything that was going on. My kids witnessed it as they told the cop. Daddy was just trying to protect Sissy.
Okay, well, my question is, but you didn't answer my question. My question was, do you want her order to stay away from you?
I don't wish that she stay away from me because as long as there's no alcohol, we don't argue, we don't say like that. I can call, and I'm still supposed to be going on this job. They highly sought me out for this job. I just need to get on the phone and call them and tell them what's going on. And I'm probably going for 30 days anyway, which will allow us time to get through it.
All right. No protection order then will be entered on this case. He doesn't want one. But you are ordered to stay away from her. So I'm letting her go back to the house, because that's my understanding. Her mother is there with the children.
Her mother's there with the children, that's another thing, a whole other battle there.
Okay. Well, you can discuss that with Mr. Delauder, but I need some arrangements. We've called Children's Services. They're going to be involved. And I'm setting a hearing on her case for Friday. You're telling me you're going to be out of town Friday?
I don't know.
Okay.
You said it, and I'll either have a lawyer there, or I'll be there, whatever it is that.
I'll set it for Friday then. September the 8th will be your next hearing for a pretrial. I'm going to let you sign an OR bond of $1,000. You understand what that means? Okay, you're going to sign a piece of paper. You're signing your own recognizance. You are guaranteeing your own appearance. So you just sign a piece of paper that says, I promise to come to court when I'm ordered, and that's going to be Friday. If you don't show up, you get a warrant, and you have to pay $1,000 for not showing up. So just show up at 10 o'clock on Friday. Stay away from Aaron until then, and get in touch with Mr. Delauder. Next hearing will be Friday at 10 o'clock.
And Your Honor, we prepared a protection order for him to sign before he checks out of the jail.
We'll send a protection order down for you to sign, because I've ordered you to stay away from her.
Okay.
That's all.
State of Ohio versus Christian R. Shavers, case number CRB 23468, and Corey Cordell is on deck.
Ma'am, are you Kirsten Shavers? Can you hear me okay, Ms. Shavers? I'm Judge Capper at the Lawrence County Municipal Court. This is your arraignment hearing. It alleges that the charges are filed against you alleging on August the 1st of this year in Fayette Township, you purposely deprived Walmart of property without their consent. It's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge? It's alleged that you, from the affidavit, it looks like alleged that you took food and ate it on the sales floor and took the bag that was in and hid it somewhere and then left. That's the allegation. Do you have the money to hire a lawyer?
No,
Okay, how do you wish to plead?
Guilty.
A guilty plea means you're admitting the charge is true, you waive your rights to have a trial, to have a lawyer if you enter a guilty plea. You understand that?
The only thing with it is that I was planning on still paying for it. I was leaving to go get money outside when they got me.
Okay. Well, the allegation is that you were cited to come to court on August the 4th and you didn't show up. Do you have an explanation for that?
No, I just missed my court date. I didn't mean to, but
Then I guess you got arrested on this warrant. How'd that happen?
I got arrested on failure to appear.
Yeah, how'd that happen?
What do you mean?
Well, did you turn yourself in to jail? Because that makes a difference. If you come and turn yourself in, then I treat it differently than if you had to be snagged and drugged to the jail.
No, they just came by and asked my name and my social and pulled it out the warrant.
Okay, came by where?
Outside CVS.
Okay, because I had an Ashland address for you. Is that where you live in Ashland?
Yeah. I live in Kentucky.
When did this happen? When did you get snagged?
It was just a few days ago.
Okay, take any position on something?
No, Your Honor, the jail time maybe would count towards something.
All right. How many days do you think you've been in jail?
5, I believe.
Oh, wow.
I came in on September 1st.
The jailer said, last Friday, you had time, you came in on Friday, you got to spend all Labor Day weekend in jail.
Yes, yeah.
If you would have come to court, if you would have done what you were ordered to, you wouldn't have had to spend any time in jail.
Yeah.
So did you learn something from this?
Yes, yes.
What'd you learn?
Definitely made my court dates.
Make your court dates. Don't go to Walmart to shoplift either.
Okay.
Okay, I want to have you screened. I want a urine screen before I go any further. I don't know if it'll show anything at this point, but I have you screened and we'll come back and decide what your sentence should be. So go do urine screen.
State of Ohio versus Corey A. Corda, case number TRC 23906, A, B, and C.
Mr. Cordell is being evaluated by RRS. Looks like we got OVP involved too.
Yes, sir. Just due to the amount of methadone he takes, I'm not comfortable placing him in the building. But I've spoken with Bree, and she hasn't been available Thursday.
Okay.
We can take him in to get him tapered off of the methadone so that he can then continue to RRS as long as that's something he's willing to do.
Did you hear that, Mr. Cordell?
Do I hear what?
RRS doesn't want to take you. Maybe you could have like Paul on the road to Damascus, you might have a conversion experience right here and decide you want to go to Bethesda, because I think they can take you.
Like, I'll go where I go. The question is, will they taper?
We do taper.
They will taper you, they said.
That's fine. I'll do it. Just, like, I'll see, like, help me, please. That's all I'm saying.
Can you take him today?
I will.
All right, so now you realize it's faith-based, and you don't have to go to a faith-based facility if you don't want to.
That's fine. I believe in God, I'm Christian. That's fine.
Well, I understand you grew up in a Christian household, or sort of Christian, is that right?
Yeah, my dad was evangelist.
Okay. Well, maybe there's some stuff there that needs to be worked on.
I'm not false contact.
Okay, so I'll order Mr. Cordell released to Bethesda today to start inpatient and come back here. Let's just keep, I had a review hearing set for him for the 15th, so we'll keep that. I'll see you on September 15th. Someone will pick you up today.
Thank you, Your Honor.
You're welcome.
All right, thank you. You know about how long that'll be?
I'll be there as soon as the papers go.
Yeah, sometime this afternoon.
Attention jailer, Kristen Shavers will be on deck as soon as she gets her urine screen completed there.
Yes, sir. We'll take care of that right now.
Thank you.
You're welcome.
State of Ohio versus Benjamin L. Shepherd, case number CRB 23240. Benjamin Shepherd.
I don't believe he's here.
He's supposed to be at OVP.
He's supposed to be at OVP.
Yeah, I spoke to OVP Proctorville, and he's still never reported there for any other appointments. She said that the last time he was there, he told them that he probably wouldn't be back because he was under the impression that he was going to be done with all of his court stuff. But yeah, he never came back there. Last he was seen was on the 20th of July.
Oh, okay. Well, state requesting a warrant then. This is a misdemeanor.
Yes, and this, as I recall, is two brothers that got into it. They both live with their mommy, and he promised to go to treatment and hasn't cooperated with that. And it's been some time, hasn't it? I mean,
It has.
all right, so I guess all we can do is ask for a warrant.
Be a warrant issued for Mr. Shepherd for failure to appear and failure to go to treatment as agreed.
Yes, Your Honor.
State of Ohio versus Kaylee M. Sturgeon, case number CRB 23458.
Your Honor, we're set for,
Ms. Kaylee Sturgeon is Mr. Stratton's case.
sorry, Your Honor. We're set for a pretrial today. I understand that the state is waiting on a statement from the alleged victim in this case, which the state believes might be for dismissal. If that's what that statement says, we're going to do a 90-day dismissal on it. And of course, if there's no further problems.
We have had contact with the alleged victim, and her mother also. And they were supposed to drop us off a written statement that she didn't want to pursue the charges. However, that's what they said they intended to do. And we're okay with doing a 90-day continuance with a dismissal at the end upon the payment of court costs if there are no problems and if there are no further, and if the court costs are paid. And if we found out that the reason they didn't bring a written statement in was because of some further problem, then that would cause us to not follow through with that either.
Yes.
Okay, so let's go 90 days out. September the 8th, or I'm sorry, December the 8th. December the 8th will be the next hearing.
Just make sure we have costs that day. That should be okay. It's like 100 and something, so.
If there's no further problems and the costs are paid before then, she doesn't have to appear.
Yes, so if you come in and pay before that date, and there's no other problem.
But she has to appear if she hasn't paid the cost, or if there's been problems.
Yep. No problem. I think that's it.
State of Ohio versus Kenneth Roberts, case number CRB 23142. Kenneth Roberts.
Mr. Roberts is not here, Your Honor. He was supposed to go to Bethesda. He had an assessment scheduled with Bethesda, but I don't believe he ever showed up at Bethesda, did he?
He did.
Is he still there?
He came in as, just to do his assessment. May I approach him?
Yes.
Mr. Roberts has a very limited history that our facility does not allow him. There's a previous charge that he went to prison for that we're not allowed to have in our facility. I have spoke to Brandon at Mended, and he was willing to assess him to see if they could take him, but the charge is pretty severe, and I'm not for sure if any facility is going to be able to take him.
Well, he's not here either.
Yeah, he's not here, so.
Normally Christmas.
Mr. Hill?
Well, Your Honor, we're concerned about his well-being, and I have the victim of this. This is a sentencing hearing.
It is.
And she says that he's got some serious drug problems. So I think we would need to have a bench warrant issued.
That's all we can do since he didn't show up. We'll have a warrant issued for him, and he'll be placed in custody once he's contacted. So bench warrant issued for failure to appear today.
Okay.
If you can get him to come in, ma'am, that would be good.
Yeah.
We'll try to reach out as well. Thank you, Your Honor.
See, I had a criminal charge, and he called down there to the police station. He had some girl call down there and drop those charges.
I don't know about that. He pled guilty to a charge here, which could carry 6 months in jail. We're serious about it. If he doesn't want to see the light, by golly, why is the court to put him in jail for a while? Okay? Now let us know if you have any problems, and if you have a way to go.
Well, see, he don't have my phone number, so there's no way for me.
Well, then we'll just have to wait till they arrest him, and then we'll deal with him. If you have any problems with him, you call law enforcement.
Oh,
Okay?
Oh, I definitely will. 'Cause
Okay.
after what he did to me on the 13th, shopping me from the wall, trying to kill me, and then he said that if that didn't kill me, he was going to shoot me. Yeah, I'll call you.
Okay, now listen.
State of Ohio versus Charles Hutchison, case number CRV 21584, PRC 192635, and PRC 1812.
Okay, Mr. Hudson is here and being represented by Mr. Green. He's at OVP.
Secretary, I've got a report on that approach.
Yes. So is he in the inpatient now, or?
Yes, he's currently with our inpatient program.
So he's going to graduate September 20th and then recommendations for outpatient after that?
Yes, at Dr. Bill OVP.
Is that agreed to, or?
Your Honor, my client wishes to be potentially considered early for outpatient. I spoke to him and his grandmother today. His grandmother has indicated she's having all sorts of problems, doesn't qualify for any type of in-home assistance, and needs him in the home. She's falling and there's no one to help take care of her. So I don't know if that's something the court would consider based upon the positive report provided by OPP.
What's being recommended? I mean, I think I'm not the one that came up with his treatment plan, so.
Well, it was recommended that he complete the 30 days. I'm unsure if he's discussed this with his counselor or anything like that.
There's nothing in the report about it.
So maybe now that it's been brought to my attention, whenever we go back, we can kind of discuss that with the treatment team and try to come up with an answer that way.
Mr. Hill?
Well, we would be willing to follow the guidance of the counselors as far as what his treatment needs are. I know that this case has been going on for a long time, and I also know about Ms. Hutchinson's reticence about wanting us to pursue the charges, but she also knows that he needs help. So she's previously said, too, that she doesn't want a protection order, but I think we've been through this before.
Yeah, well, I'm going to leave it this way. You need to follow whatever the treatment team sets up for you as far as treatment goes, and do that. I don't know if there's any way he can have some releases to go help his grandmother and come back, but he's had a long-standing problem.
Yeah, I know.
Alcohol and drugs. Alcohol first, then drugs, I think, mostly. Whatever we gotta do to get that under control is what we gotta do. So I would think she would understand that because she's usually the victim in any kind of criminal case that brings him before the court. So whatever we gotta do to, and it appears to me that his substance use is the reason that he incurs criminal charges. So to get that under control, I think we'll stop having him back in court
Absolutely.
for criminal charges. So follow what your treatment team sets up, and let's come back for another pretrial. I'd like to do that on or around the 20th of September, how about the 18th?
It's Mr. Morford's case, Your Honor.
Okay.
He's typically here, so.
Let's do the 22nd, so that'll be after the completes. So let's do the 22nd. September 22nd for pretrial.
Thank you, Your Honor.
Thank you,
Thank you, Your Honor.
State of Ohio versus Stephen Stanley, case number CRV 23148, CRD 22184A and B, CRD 193337, and CRC 191194, CRV 19329. Stephen Stanley.
Your Honor, you had ordered Mr. Stanley to come for an assessment, and he never showed up.
You're standing in for Mr. Morford.
Standing in for Mr. Morford. When I spoke to Mr. Morford about this case prior to him leaving for a medical appointment, he had indicated that he didn't have any information as to why he wasn't here at this time, Your Honor.
And I believe he does have a bond check. I made a note that there was a bond. Yes.
If we can maybe have 7 days before the warrant issues, to give Mr. Morford an opportunity once he's...
Well, I'll just continue it for 7 days because Mr. Sowards likes to have the warrant issued immediately. So I'll give him a continuance for 7 days then. If he's not here on, well, it'll be more, it'll be, let's make it the 11th, so 6 days technically. He's got 6 days to appear on continuance, and then there'll be a warrant issued if he hadn't appeared then. I'll let Mr. Sowards know that he failed to appear. I didn't issue a warrant though.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Todd A. Daniels, case number CRV 23344. Todd Daniels.
He's not scheduled until Monday. I was here today to drop the protection order.
I was saying Mr.
Yeah,
Morford
that's
only had
correct.
2.
Okay, hold on just a minute. I'm still working on the last one.
Yeah, it's not that last. That's our father. He's not scheduled until the 11th, but she can be here. She wants to drop the protection.
Todd Daniels is also Mr. Morford's case, 23-344. And it's actually scheduled for Monday, coming up, September the 11th. And you must be Michelle Anderson.
I do.
And you're asking that no protection order, or that protection order be withdrawn?
Correct.
Okay. Any objection to that, Mr. Hill?
No, Your Honor.
All right, ma'am, at your request, protection order is withdrawn.
Thank you.
You're welcome.
State of Ohio versus Dustin Branham, case number CRB 12-1046.
Well, we still have things to work on.
Your Honor, I have a little bit more information for the court as well. Speaking with Mr. Brandon, he is currently with Dr. Elaine Fields at Fresh Start in Ashland. He's attending counseling and group counseling there as well. That's where he gets his buprenorphine prescription.
Okay. Well, I'm afraid he's going to have to post a new bond because I don't trust him to come back without a bond. State take any position on this?
We would ask for a $2,500 cash assurance bond, Your Honor.
Okay, I'll set bond at $2,500, cash or surety. And set it out a month. Next hearing, hold on, sir, we're not finished.
We could do, I think I'm here October 2nd, Your Honor.
Okay, October 2nd. Do you have health insurance, sir, through your job?
Yes, sir. I'm not going to have it soon.
Well,
Sir, may I speak? Is that possible?
you can, it's all on the record, whatever you say.
I understand. I know what I done is wrong, and I left work being done. I was sober for 5 years, and earlier this year I had a loss, and I wasn't sure how to deal with that, but I'm working back toward getting sober again. I know that it doesn't look that way, but I am. I'm going to counseling. I'm going to family counseling to deal with that. I have a good job. I'm trying to maintain that job. I can.
Does your employer know about these circumstances?
Yes, sir.
Well, maybe they would help you with, can you post the bond?
I can post a bond, but if I don't go back to work today, if I don't go to work today, I'm not going to have a job. I mean.
Well, let's get you out and get you back to work.
It's going to take a while to post, off. Has to work till 6 this evening.
Well, I can't just let you out because I don't trust you, because you did not come back to court previously, so.
I understand.
Things have consequences. So, I mean, I'd like for you to keep your job. If you want me to call your employer, I can do that. Is that Terry Callahan?
No.
Probably don't want me to talk to him?
We can come in here and
Okay, October 2nd is your next hearing. I need some reports. You're living in Kentucky. My preferred, I'm not telling you I won't consider where you're going, but my preferred agency in Kentucky would be ARC. They have a representative here today.
Sorry. Yeah, all right,
Because obviously where you're going now is not working. Do you want to talk to their representative? It won't hurt. He's here. Once you talk with him, your lawyer can be involved in it too and see if you can work out something. Okay, next hearing's October 2nd, 10 o'clock. Yes. Well, this is from July 3rd. No, September 3rd. Okay, let's go back on the record now.
Hey, Brian.
On Ronald Ferguson, case number 23 TRC 0923, it was actually on the docket for last Friday. No, last Monday, a week ago. I'm going to withdraw the warrant, give this guy, there's been some documentation. He was admitted inpatient at St. Mary's, has subdural hematoma. He was discharged September 3rd. So, he should be available September the 11th, I would think. So, I withdraw the warrant, continue to September the 11th for pre-trial. 10 o'clock.
Thank you, Your Honor.
You're welcome.
May I?
Yes.
State of Ohio versus Christian R. Shavers on a recall at the Lawrence County Jail, case number CRB 23468.
It's actually Kirsten. It looks like Kirsten, but it's K-I-R-S-T-N, Kirsten Shavers. All right, Ms. Shavers, can you hear me?
Yes.
Okay, you tested positive for benzodiazepines. Is that, do you have a prescription for that?
That should be, I haven't taken anything like that.
Okay. All right, I'm going to refer you then as part of your sentence to ARC for evaluation and treatment. Addiction recovery care in Ashland. You live in Ashland, so do you have a Kentucky medical card?
Yes.
Okay. What's the address in Ashland, Jeremy, where she can? Do you know where ARC is? Have you been?
No.
Does she know where Taco Bell on Winchester Avenue is?
I'm sorry.
Taco Bell on Winchester Avenue?
Do you know where the Taco Bell is on Winchester Avenue?
Yes.
Right beside it.
Right beside of it. And can she walk in or she need to call?
She needs to call me.
Okay. Well, why don't we do you have a cell number, Ms. Shavers, where you can be reached?
606-371-9283.
Okay, so someone from ARC is going to call you and set up something for you to get in there and get evaluated.
Okay.
And if you don't do it, I'll have to issue a warrant for you.
Okay.
Okay, I'm going to give you a $100 fine and court costs, 20 days in jail, and I'll suspend 15 and give you credit for 5 you've already served. I'm ordering you stay out of Walmart. I'm ordering that you do assessment and treatment if indicated with ARC. 5 days of community service, and you'll have a review hearing on October the 30th. So Halloween, or trick or treat night, you gotta come to court that day for a review at 9 o'clock, and we'll get a report from Park as to if you've been there, done what you need to do.
Can you change my phone number to 606-923-0023?
Whose phone number is that?
That's just the best way to reach me.
Okay, you got more than one number?
I'd rather be that one.
Okay. All right, he's got it. Okay, so you're gonna get out of jail today, but you gotta go to treatment, and you gotta stay out of Walmart, and you got community service to do, and a review hearing on October 30th. You gotta be at the court in Chesapeake on October 30th at 9 a.m., or you'll get a warrant. Okay?
State of Ohio versus Tanya R. Gentry, case number CRB 2374, set for noon arraignment on Blue Jean Charter.
Okay, Tanya Gentry. All right, she's here. Tanya Gentry. Yes, I'm reviewing your file. Okay, I withdrew the bench warrant, let you appear for arraignment today by teleconference, and you are doing that. So it looks like what happened here, you had an arraignment back in February that you failed to appear for, so you've never been arraigned on this charge. It's a theft offense from Walmart. The charge alleges that on January 25th of this year, you tried to deprive Walmart here in Lawrence County in Fayette Township of property without their consent. Maximum penalty for that, 6 months in jail and a $1,000 fine. Do you understand the charge? Do you understand the rights you have? You have a right to remain silent. You don't have to say anything. You have a right to have a lawyer appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things? I didn't understand what you asked me. What did you say? I still don't understand. What are you asking? It's not coming through, it's just garbled. There's, that's better. Well, for a second it was better, now it's not.
I'm sorry?
Okay, now you're better. Say it again.
Sorry, the last part that you said to me, I didn't understand that.
Oh, as far as your rights, you have a right to have a lawyer, to have one appointed, to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay. What plea do you want to enter to this charge?
I want to plead guilty.
Guilty means you're admitting it's true, and you do that, you waive the right to have a trial and to have a lawyer. Do you understand that?
No. Okay, sorry, I did not understand that. So now, would like to plead not.
Okay, do you want a lawyer appointed to represent you?
Yes, sir, please.
Are you working now?
Yes, sir. I'm in a facility, Charleston, West Virginia, operating code. After tonight, I'll have time tomorrow in Point Pleasant, and today I will be 100 days sober.
Okay, so are you just working part-time now?
No, sir, I'm on 80 hours every 2 weeks.
All right, are you paid by the hour?
Yes, sir, I am.
How much per hour?
$10.
Okay, you're entitled to court-appointed lawyer. I'm going to appoint Mr. Smith. He's here in the courtroom. He's been watching and listening. This is Tiffany Lipscomb. She's at a facility in Charleston in treatment and working in And this is an old shoplifting charge from January. So I'm going to appoint Mr. Smith to represent you. What's your phone number where he can reach you?
Yes, sir, it is 304-542-8412.
8412. Okay, I'm entering a not guilty plea for you.
I'm sorry?
I've entered a not guilty plea for you.
Okay.
And then I'm going to set another pretrial. And Mr. Smith will call you and talk. We need to get some verification about your treatment would be good. So, how about September 25th, Mr.?
That's fine, Your Honor.
I think you're already here that day.
Yes.
Okay, I'm setting your next hearing for the last Monday in September, which is September 25th at 10 o'clock. I've withdrawn the warrant that had been issued for you.
Yes, sir, I greatly appreciate that.
So as long as you're in treatment, I'll let you appear by teleconference.
Yes, sir, I'll be in treatment until January 10th.
Okay. Mr. Smith will call and talk with you about your case, and then I'll see you again on September 25th.
Okay, sir, thank you so much.
You're welcome.
Have a good day.
You too.
State of Ohio versus Casey J. Jackson, case number CRB 22510, CRB 22165 A and B, ARD 222595 A, B, and C.
Okay, this is set for trial. Yes.
Trinity?
Okay, I'd set at least one of these cases, the 22510 was set for trial today. How's the state going to proceed?
Well, Your Honor, I believe what happened was, the last time we were here, Mr. Jackson, we'd been talking about him following through with his treatment, and he kind of ran aground there a little bit, wasn't complying and whatnot. And I think that the only thing left to do was to set it for a trial. But we also, in the meantime, we're hoping he would do what apparently he's done, and that is to decide maybe it is better to do the treatment. And I know that this young lady here, Ms. Cremines, would prefer not to be a witness in a domestic violence trial with him. She would prefer that he finishes the treatment also. So what we would like to do is go ahead and give him that opportunity as we had planned before, seeing how he's already jumped back in and is making some efforts.
Mr. Smith?
Your Honor, I think after talking with Mr. Jackson, I think that's the best route. Hopefully, he gets to where he needs to be, where he's doing this, and we're not having to keep on coming back with poor reports that he's doing what he's supposed to. So I'd assume that it's probably a shorter leash now than it was, but based on Mr. Hill's recommendation, I would agree that let's try to maybe set for a pretrial, see how he does with the next report. Hopefully he's towing the line.
All right. Ma'am, are you agreeable with that?
Yes.
And are you Trinity? You see improvement with him, or are you all still have some kind of relationship.
I mean, he's helping me and stuff a little
Okay.
bit. We're all right.
Do you have a child together or what? Okay. Well, that's important. How old's the child?
30.
You're going to be together, I mean, that really the rest of your life,
Yeah.
in some sense. Really intense for the next 15 years. After that, not so much, but there's still going to be stuff where you have to be together. So it's best if you can work this out and get him lined out. He's the father of your child, so that's a relationship that's not going to change. So, about October 2nd, I know you're here that day.
Yes, sir.
All right, next hearing will be October 2nd. Hopefully we get continued better reports. Back October 2nd at 10 o'clock for pre-trial.
Thank you, Ron.
Josh was staying on Friday.
Thank you.
State of Ohio versus Kyle G. Sias, case number CRP 23465. Kyle Sias.
All right, you're Kyle Silas.
Yes, sir.
This is set for trial today too, so. And I take it you don't have a lawyer, right?
Yes, sir.
How's the state want to proceed on this?
We are, as long as my witness is here, hopefully, we're ready to proceed. In the alternative, this is filed as a minor misdemeanor disorderly conduct, and we would not take any position on the fines and court costs if he were to plead guilty.
You want to have a trial then, Mr. Silas?
Yes, sir.
Okay. All right, you can pull up a chair and have a seat there. We'll proceed with the trial. I've got two officers subpoenaed, Dr. Cochran and Osborne. Here they are.
Yeah, probably should. And do that.
Okay, would you raise your right hand, please? Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Deputy, could you state your name and where you are employed?
My name is Deputy Brian Cochran. I'm employed with the Lawrence County Sheriff's Department.
Were you employed with the Lawrence County Sheriff's Department on the first day of August of this year?
Yes.
And at that time, did you have occasion to be called to a situation involving Kyle Sias?
Yes.
Do you recognize Mr. Sias today in the courtroom? And if you do, could you point him out, please?
I do. Mr. Sias is here in the brown shirt.
The record will show you pointing to the defendant.
Were you dispatched to 153 Township Road, 362 in South Point?
I was.
Do you recall making contact with Mr. Sias there when you arrived at that place?
I did.
What did you observe when you got there?
I spoke to his sister out front. She advised me that he was in a very agitated state. He might not talk to me, and I just reassured her that we would go ahead and just try. So she led us through the house into the backyard where he was. He definitely was a roller coaster of emotions. I mean, he was all over the place. When he saw us, he tended to get a little bit agitated, but we just told him we were just here to talk. We tried to explain to him that the reason we were there, and he started getting a little bit more confrontational, and then he lunged at one of us at the door's mom. We just explained to him that we just needed him to calm down a little bit. At that time, he still wasn't really receiving that.
In your statement that you made, your affidavit, you indicated that he was under the influence of unknown substances due to his hallucinations and
Right.
comments that led us to believe that he was not in his right state of mind. Can you elaborate on that?
Is there any way that I can see my narrative, like this is the first time? I was looking in the narrative to see whether or not I mentioned what he was talking about, but I do remember him talking about something along the lines of the FBI or something that they were spying on him.
Was he talking about things that were not associated with the reality that was going on there?
Yes.
Did he appear to you to be under the influence of some sort of a illegal substance or some sort of a
He did. He was
substance that
definitely-
would have made him disassociate with reality? Like,
He definitely seemed to me like he was under the influence of something, although repeated times I asked him, he really wasn't able to tell me what he took. He was sweating profusely, didn't have a shirt on, eyes were really hard to see.
was he causing a disturbance, like with yelling, or was he loud?
He kept, like I said before, it was a roller coaster of emotions, so like he would get loud and we would talk him down just a little bit, but he was arguing with his sister about letting us in, and he was arguing with the deputies there, myself and Deputy Worthington.
Was it his sister that called in the report, to your knowledge?
To my knowledge, yes. And on the way, dispatch advised us that one of our other deputies, Deputy Mullins, had already dealt with him a couple hours prior. At that time, he was advised just to go ahead and go home and rest it off.
So Deputy Orsbon was there with you?
He was.
And you were there, and his sister was there?
Yes.
Were the EMS also called to the scene?
EMS was called to the scene just to verify that he was okay and just check his vitals before he went clear him for death.
Did he cooperate with them?
No, he was really set on not wanting to go to the hospital, but he'd just rather go to jail. So at that point in time, he was placed under arrest.
Were there any other people who showed up there, family members or anything like that?
There was a friend of the family, but she was there with his sister. I did not catch her name.
Was he aggressive towards anyone?
He had made a motion towards his sister, but we were already present there. As for what happened before, I was not there. I don't know.
You get a chance, just, he was raising his hand, that's why you get a chance shortly.
And I'm going to refer you back to your criminal affidavit that was filed with the charge and see if this refreshes you about something specific.
Yes, that's what I was looking for in the narrative. Okay, my narrative does state that he was in the backyard yelling and screaming about being ripped off and threatened over a bag of liquor.
He was upset over that.
Yes.
Do you, Deputy, believe that Mr. Sias's behavior was likely to be offensive or to cause inconvenience, annoyance, or alarm to persons of ordinary sensibilities?
I do believe so. I had dealt with Mr. Sykes there at that address one other time prior, and at that time I was able to talk him into going to the EMS. This particular time I was not able to.
So that's a prior occasion you're talking about?
Prior occasion, yes.
So did you arrest him?
Yes, this occasion I did arrest him.
And there were more than 2 people there present when he was behaving like that, is that right?
Yes, that's correct.
That's all I have, Your Honor.
All right, Mr. Sias, now you want to ask questions to the witness about their testimony. This is the time to do that. Do you have any questions you want to ask?
No questions, sir. Couple statements.
Well, we'll get to that in a minute. We're not to that point yet. This is what's called cross-examination. I know you're not a lawyer, but that's
Okay.
what's next. So, all right, you can step down. Thank you.
Thank you.
I'll call your next witness.
Will rest, Your Honor.
All right, so now, Mr. Sias, is the time, if you want to call a witness on your behalf, or if you want to testify, you can do that. You don't have to. You can't be made to testify. You have a Fifth Amendment right against giving testimony if you don't want to, but you can do it voluntarily. You're waiving your Fifth Amendment right to remain silent if you take the stand. Do you want to give testimony, or do you want to call a witness on your behalf?
To be civil matter, I think I would like to just kind of let things go by. He said a little bit of the truth, but he didn't say the whole truth.
Okay. Well, that's up to you. You can't be compelled to take a
What
witness
of my
stand.
head? What's held over my head at this point?
This is a non-jailable offense. So the max you can get is a $150 fine. That's
I
the
realize
maximum.
that. Like I said when I was here the last time, I was pleading not guilty because I am not guilty, but you said if I pay the $150 fine, I'd be pleading guilty.
Well, so you don't want to put on a defense then? Is that what you're telling me?
I don't understand what that means.
Well, you're not going to call a witness and you're not going to take the stand. So they've presented their evidence. You're not going to present any evidence.
I'll present some evidence.
You want to take the stand then and testify? Or you can call another witness. That's what evidence is it has to be something that the court deems relevant to the case and comes in under oath.
Well,
either testimony or some sort of
Is there any
document.
way I can just pay the fine and not plead guilty?
You can enter a no contest plea, and that means you're not admitting that you're guilty, but you're not fighting it either.
Will I get a misdemeanor on my record?
You'll have a disorderly conduct.
I mean, I'm not trying to cause trouble with the law, and,
A disorderly conduct
It's
is
a
a minor misdemeanor, and it is, I don't think it would ever stop you from getting a job or something down the road, but if it's a problem, it is the type of offense that can be expunged in the future. And that means it can be taken off your record down the road.
How long?
It has to be completed for over a year, I believe. For
A year and it drops?
No, it doesn't automatically drop. You have to file something to get it dropped. An
Well-
expungement, you have to file an expungement. So, I need to know, do you want to testify? Do you want to rest your case and not present evidence, or do you want to change your plea? That's where we are now.
I'll waive it.
Okay, so you're not gonna present any evidence?
No, I'll plead no contest and pay the $150 fine.
Okay. I'll accept your no contest plea. I've already heard the state's position on the state taking a position on the sentencing.
Your Honor, and I say this with the utmost respect to Mr. Sias.
I can show you some more evidence that shows that. I just left treatment, and not that I was on drugs that night, Your Honor, but I'm in Western Regional Day Report Center. I check in Monday through Friday. Here's a list of my medications.
Okay,
And
take a look at that.
I also just left my outpatient treatment. I got there at 10 o'clock. You can take off too. I got there at 10 o'clock this morning and there was a cancellation, so I'm doing outpatient treatment, but I was not on drugs that night, Your Honor. And the being threatened over a bag of dope, that was at a situation that needs to stay off the stand, you know. That wasn't involving me and a bag of dope and any persons. It was an officer that came to a scene that my vehicle was stolen, and he said, you don't know where you're at, that your life, you could get shot out here over a dime bag of dope. And then the state came.
All right, well, apparently you're under some sort of supervision over in Cabell County, right?
And multiple.
So I'm not gonna add, and I don't think I could add anything to it over here. So I'll impose a $150 fine and court costs. Do you need time to pay that?
No, sir.
You can pay it today?
Yes, sir.
See the clerk to the right as you leave the courtroom.
State of Ohio, Brian Montroso, case number CRD 1733, CRD 15543 A and B, CRD 14593, and TRC 111387.
All right, Mr. Montroso is here today. And are you here early? Looks like this was set for, maybe it was set for the wrong day. Now, you had failed to appear, it looks like, on August 28th.
Last week.
A week ago. Okay. You admit that?
Yes, sir.
Do you have an explanation?
Yes, sir.
And you got Mr. Sowers after you?
No, I talked to him.
You got a bond up.
Yeah, I mean, I talked to him, Gary.
And, are you paying anything on your fines today?
Well, I was going to, but I had to go across the bridge. Now, I had to ride my bicycle to come down here. It's the only way I could get down here to ride my bike. But if I went across the bridge, I couldn't have come here to get my check, which I got at 10 o'clock over at Steve's at Marathon. So I told him to just keep my money over there, and then if I get out of court, whatever, that I can bring money back or whatever. But Steve's got it over there for me.
Who's Steve?
Steve Awad. He owns Marathon over there on 31st Street Bridge. I don't know about owns it, but runs it.
Okay. All right, I'll cancel the warrant and I'll give you, when can you have something paid?
Today.
Today?
Today.
I'll set your next hearing for October 2nd.
Okay. Let's make a payment today.
These are sentencing because he does have a bond up.
But you want me to make a payment today, right?
Yes.
Okay, what date is my date again?
October 2nd, the first Monday in October.
Okay, thank you.
October 2nd. Gotta get it here by 4.
All right, thank you.
You're welcome. Okay, court's adjourned.